Good afternoon, Your Honors. Alan Groves on behalf of the state. I'd like to reserve 6 minutes for rebuttal, please.
All right.
This is a straightforward sentencing case. The trial court wrongly imposed a misdemeanor sentence for a felony offense, which is patronizing prostitution from a law enforcement officer posing as a minor. The text, structure, and history of this statute show that this offense is, quote, punishable as sex trafficking, which is generally a Class B felony. Because the trial court concluded otherwise, this court should reverse and remand for resentencing. And so I would like to start with just the statutory text of 3913-514. And in subsection B 3A, the text clearly says that patronizing prostitution from a person who is a law enforcement officer posing as a minor is punishable as trafficking for commercial sex acts under 3913-309. Our position is that this text clearly and unambiguously imposes felony punishment for this offense by incorporating 3913-309. When you go look at the sex trafficking statute, that offense at a minimum is a Class B felony. It's only a Class A felony when there's a minor involved as the victim. So we think this court can look at this statutory text in subsection B 3A and conclude just based on the text that this is unambiguously a felony offense, contrary to the trial court's ruling. I also think you can look at the broader structure of this statute. Subsection A creates two separate offenses. You have patronizing prostitution under subsection A1, and then you also have under subsection A2 patronizing prostitution when you have the intended victim as either a law enforcement officer or a law enforcement officer that's 18 years of age posing as a minor. These are two separate offenses, although they are in the same subsection. That's going to pair nicely when you get to subsection B, because subsection B identifies two different offense classifications for these two separate offenses. B1 specifies that patronizing prostitution is a Class A misdemeanor, and then you've got B3A, which talks about when the intended victim is a law enforcement officer posing as a minor, that's when the felony punishment kicks in. So, I'm sorry, Judge Montgomery, I thought you were about to ask a question.
Well, I sort of have a question.
Yes.
Okay, so this was a guilty plea,
Correct.
and I assume there was a plea agreement that was submitted to the court.
Correct.
And so did the plea agreement set out what the level of felony was or misdemeanor?
So the state has maintained throughout the case that it is a felony offense. It was indicted as a felony.
Right.
All throughout the plea proceedings, it was communicated that our position is that it's a felony.
Okay, so if the judge so if the defendant pled thinking that the judge was going to do it as an A misdemeanor, then, and it turns out it's a B felony, there's not a knowing plea, right?
Well, the defendant hasn't raised the
I'm
issue.
just asking. I mean, if
That would be an argument. I think it would ultimately fail because the state put him on notice throughout the case that we were charging this and prosecuting it as a felony offense.
But why would the state go through with the plea knowing that the judge was not agreeing to accept it as a felony?
So in order to perfect our right of appeal under the Sentencing Act, we had to have a final judgment. We didn't think that we could seek interlocutory review, so that's why we chose to go through the plea process. But it was communicated at the plea hearing that it was going to be an open sentencing hearing. He was pleading guilty to the offense of patronizing prostitution from a law enforcement officer posing as a minor. There would be an open sentencing hearing where we contested whether the offense classification was a misdemeanor or a felony. But that was known at the plea hearing.
Okay, and so there was argument then, even after the plea, as to whether it was a felony or B felony?
Yes, it was an open plea. So there was an open sentencing where this issue was again relitigated.
So there was not a plea agreement. I think you used the word agreement earlier, but there was not an agreement. He just entered a plea, but it was open with regard to whether it was a felony or a misdemeanor and the length.
That's my understanding of the record.
Okay.
And of course, the defendant can always seek further relief. There are other rules and statutory mechanisms to...
No. The fact that it was an open plea is a little bit different. I misunderstood something.
Yes.
So the plea, did it say what charge he was pleading to?
Patronizing prostitution from a law enforcement officer posing as a minor. Yes. So I've kind of discussed like our textual argument, the broader argument from structure and the statutory context. I also thought it would be helpful just to walk the court through the history of this statute and how we got to where we are. So patronizing prostitution has always been a misdemeanor, that like baseline offense. And then in 2011, the legislature added this sentence enhancement for, at first it was limited to minors and for victims who were intellectually disabled. And in 2011, when that enhancement provision was added, it specifically said this is a Class E felony. So that's always been a felony. And then in 2014, as far as I could tell, that's when the legislature changed the Class E felony language to is punishable as sex trafficking under the 309 statute, which is now the language that we have, which effectively increased the punishment from a Class E felony to a Class B felony, or an A if it's an actual minor that's involved. In 2019, the legislature added the provision to the offense statute clarifying that when you have a law enforcement officer posing as a minor, that can constitute patronizing prostitution. But the legislature failed to also amend the punishment provision, that enhancement provision, which is why this court in the Ashley decision in 2013 held that patronizing prostitution from a law enforcement officer posing as a minor was still a misdemeanor because the legislature had failed to amend that part of the statute. But this defendant, importantly, was indicted after the 2022 amendment, which fixed the problem in Ashley, which specifically says the law enforcement officer posing as a minor offense is punishable as sex trafficking. So we're not dealing with the same fact pattern as Ashley because we're under that amended statute. And the defendant's argument seemed to be driven by Ashley in the trial court. And the state pointed that out to the trial court, but ultimately the judge decided that the statute was still ambiguous and then applied the rule of lenity to rule in the defendant's favor. But because the statute's not ambiguous, it wasn't necessary to invoke the rule of lenity. And on appeal, the defendant's main argument, as far as I can tell, is that really it's a new argument he didn't raise below, but he's saying that is punishable as just relates to the manner of service for how you would punish sex trafficking, but I'm not sure where that's coming from because there's nothing in Section 514 that references manner of service. And as we pointed out, in other statutes that use this language about punishable as, we're usually referring to offense classification, such as when forgery is punishable as theft, and you're kind of incorporating by reference the valuation and the grading of the offenses. We think that's a more close analog to what we have here. But we do think this is fairly straightforward in terms of statutory interpretation, and of course this court has a duty to construe the statute to avoid the statutory conflict that was actually created by the trial court's ruling. We think that was unnecessary, and we would urge the court to adopt a interpretation that reads these two provisions harmoniously so that you're not running into conflict or creating conflict where there is none. Happy to address any other questions the court may have, but otherwise I'll reserve the remainder of my time for rebuttal.
Good afternoon.
Good afternoon.
I'm Venus Snyder, and I represent the defendant, Mr. Guox. I'm going to first clarify the plea. Mr. Guox submitted a petition for a waiver of trial by jury and a request for an acceptance of his guilty plea. After the trial court, we filed a motion to dismiss the indictment saying that there was no patronizing prostitution as a B felony. The court decided that it wasn't going to dismiss the indictment, but that it would limit the state's ability to prosecute the defendant as anything other than an A misdemeanor. Okay? That has not been appealed. Because of that, there was no way to move forward with the state saying it's a felony and the court saying that it's a misdemeanor, and the defendant saying, okay, so we filed a petition for the court to accept the plea. And in the petition, it says that there is no agreement, that this petition for the court to accept its plea is due to the court's limiting his exposure to the A misdemeanor instead of the B felony that the state was seeking. So the petition to accept the guilty plea is really clear that Mr. Guox was relying on the court's determination that he could not be punished any further than the A misdemeanor, and that is part of the record. It's not a plea agreement. It is a petition that the defendant filed for the court to accept his plea, and they did it. So they've accepted a misdemeanor guilty plea. What can they do with that? Well, how can you have a knowing, voluntary guilty plea to a B felony if the court told you it's only going to be a misdemeanor? You agreed to that. You pled to that. All the paperwork says that. The petition for request to waive a jury trial and accept the plea says that. The judgment says that. There's no way to sentence the defendant to a B felony. And I think the state's argument seems limited to me because it says whether the trial court improperly sentenced Mr. Guox by treating the conviction offense, patronizing prostitution from a law enforcement officer posing as a minor, as a Class A misdemeanor rather than a B. But the conviction offense can only be what the defendant agreed to, the plea papers that he signed, the petition that he filed with the court and that the court accepted. So the conviction offense could not be a B felony.
Where does the defendant state or claim that the judge had the power to do this, to change what the defendant was indicted for under the statute and say, I'll take a plea to something else, without getting the state to agree to that?
The defendant filed the motion to dismiss, and this is what the court did. It is not that the defendant asked for. We actually asked for a dismissal of the indictment. But the state did not appeal that action by the court.
Did the judge issue an order granting or denying that motion?
A memorandum order, Your Honor.
Denying?
Denying the motion to dismiss and saying instead it was limiting the state to a prosecution as an A misdemeanor because the statute was ambiguous. Now, I disagree with that. I disagreed then. But that was the position that we found ourselves. I believe the statute is clear. And if you look at page 6 of the state's brief, everything is right in one sentence. The statute in question was amended to provide that patronizing prostitution, and here's where the quote comes in, quote, is punishable as, close quote, sex trafficking, comma, a B felony. Now, if they could have put that close quote after it said a B felony, I think they have it. But that's not what the statute says. The statute says that it's an A misdemeanor, and then it drops down and says that it's punishable as trafficking. Well, that doesn't have the capacity to change the class of offense from an A misdemeanor to a B felony. And it is not unusual to have language such as this, because if you look at, let's look at the rape statute, it's 3913-503. It says that rape is a B felony. But then in B it says, shall be punished as arranged to offender. That shall be punished doesn't change that it's a Class B felony, doesn't make it an A felony, doesn't do anything else. And the state argued that the defendant never argued that can be punished as speaks to the manner of punishment, the manner of service. But what else could it? It doesn't have the capacity to negate the words is an A misdemeanor. It doesn't give us new words to put in its place. We're not supposed to pick and choose the words. If we could do that, we could go to the rape statute and say, wait a minute, if it's a range 2 and it falls in a felony, maybe it's an A felony, let's go pursue that. I think, and I've always thought that the statute is clear, that the prostitution, patronizing prostitution statute only intended for it to be an A misdemeanor, and all the rest of it is noise. Is punishable as, doesn't change the class, nothing else changes the class, and we can't put words where they aren't.
But that's not what the trial judge necessarily found, is it, what you just stated?
The trial judge found that the statute was internally inconsistent.
Mm-hmm.
Okay?
That it attempts to simultaneously classify patroning prostitution from a law enforcement officer posing as a minor, as a Class A misdemeanor, and also as a Class B felony pursuant to B3A. That's what the trial judge found.
Yes.
But that's not necessarily what you are arguing, then or now.
Then or now. And it's not what the state appealed. The state's problem, according to their brief, is that he got convicted of a B and he got sentenced to an A. I don't think that the problem happened a long time ago. The problem happened with the memorandum order, and I don't need to argue, I don't think, that the trial court's how it arrived at its decision was correct or incorrect because it's not being appealed. I think the only thing I have to do is say whether I believe that the position the defendant found himself in, being charged with a statute that clearly says it's an A misdemeanor, whether the state can get this court to white out that part that says it's punishable by and put in is a B felony. If the court can do that, the state should be able to win this. But without being able to change those words, punishable as is not the same thing as is a class anything. Any more questions?
No? Anything? Thank you, counsel.
Thank you.
Rebuttal?
Just briefly, Your Honors, I just wanted to reiterate that the record will reflect that this was an open plea. In my brief, I cited the second volume of the record, page 4 and 22, where it says that this was an open sentencing hearing. And so the defendant, for the first time at oral argument, seems to be asking this court to hold that the plea was unknowing. That's just not an issue before the court. They didn't raise that in the brief. There's other mechanisms to do that. If this court rules in our favor and reverses and remands for resentencing, the defendant could always withdraw the plea or later seek post-conviction relief. But all we're asking this court to do is to say that the trial court was wrong in the way that it interpreted the statute and to hold that patronizing prostitution from a law enforcement officer posing as a minor is punishable as sex trafficking, as the plain language of the statute says, which is a Class B felony.
Well, looking at the trial judge's order, it seems like he's saying that the statute is internally inconsistent, and that the court further concludes that, as currently charged, the state has limited itself in the prosecution of the defendant to pursue a conviction for the offense of patronizing prostitution. Was there something about the way the state returned this indictment that took it out of this statute? Was there something about the language in the indictment that...
No, the indictment cited the statute, 3913-514, cited the elements of it involving a law enforcement officer posing as a minor, and then said that it was a Class B felony. The indictment was proper. But the trial court thought that the statute was internally inconsistent simply because under A 1 and B1, patronizing prostitution is called a misdemeanor, a Class A misdemeanor. And essentially, the court is conflating these two different offenses and treating them as the same offense, but having different offense classifications. But our position is that they're two separate offenses. But the state did properly charge the offense of patronizing a law enforcement officer posing as a minor. Is that responsive to your question?
I think so. Let me.
Okay.
Um,
And
yeah.
to circle back up on the defendant's point about us not appealing, this came up again in a sort of an unusual procedural posture. The defendant filed a motion to dismiss the indictment, like arguing that we somehow failed to even allege an offense. And so the trial court ruled in our favor on that issue and said, of course, it alleges an offense. It cites the right statute. It recites all the elements. But the court just sort of previewed its holding, and that it would, at sentencing, it would treat it as a misdemeanor. But at that point, we couldn't seek interlocutory review under Rule 9. We didn't think that that was an available option. So we decided the best way to handle this would be to allow the defendant to plead to the offense, but have an open sentencing hearing where we could still contest this issue. And then once we lost the issue at the sentencing hearing, then we could appeal under the Sentencing Act when the trial court imposed a sentence pursuant to the wrong sentencing range, which is under, I think, 4035 401 or 402B1. That's why we chose to wait until a judgment was entered. But it certainly was an open plea in the sense that we did not agree to a sentence. And the trial court can't make the state agree to a sentence in a plea agreement. You have to have a meeting of the minds of the parties for that to take place. And that certainly, the record will not reflect that that occurred. So.
And looking at the indictment for count 1, which is what we're here on,
Yes.
patronizing prostitution, the statute that's cited in the indictment is 3913-514, no subsections. You, if I understood your argument just a moment ago, indicated that there's actually 2 offenses set out in this one statute. Is that right?
Yes.
So
whether-
does just alleging 514 enough to put the defendant on notice that we're going, well, I do see it says here too, a Class B felony, but also contained in that same statute is a Class A misdemeanor, correct?
No, because the indictment used the element of law enforcement officer posing as a minor, if I recall. I don't have the indictment in front of me.
It did.
But that's enough to put the defendant on notice that we're proceeding under the A2.
BA2. Is that what you said?
514A2.
A2.
Yes. And again, and the defendant hasn't challenged the validity of the indictment on appeal either. So,
Well, it sounds like from reading the trial judge's order that he was struggling a bit with the indictment, with the as charged language.
yeah, and I'll acknowledge that usually the legislature, when they are creating separate offenses, will put the offenses in separate sections or subsections rather than having them in the same subsection. And then other times they will have them in the same subsection, but they'll say, except as provided in the following like subdivision. It's a class, B felony, but then it will have like an enhancement provision essentially that includes another provision. But the legislature is not required to set forth the offenses in that same way in every statute. And here, looking at the plain text and the overall context, it is clear what the legislature was doing in making this a felony as opposed to patronizing prostitution being only a misdemeanor. So I see that my time's expired. We just respectfully ask the court to reverse the judgment of the trial court and to remand for resentencing.
Thank you, General.
Thank you.
All right, well briefed and argued, interesting issue, so we'll take this one under advisement too. All right, call the next case, please.
Ronnie Lee Claiborne versus State of Tennessee.